Hello. Thank you so much for coming out to this launch of Criminal Law and Precrime, Legal Studies in Canadian Punishment and Surveillance in Anticipation of Criminal Guilt. My name is Lauren Menzie. I had the opportunity to be involved in this project, and I'm really looking forward to sharing some of my work with you today. So I'm going to be briefly talking about how administrative legal processes take on a pre-criminal punitive nature, and how certain non-criminal legal systems have begun to bleed into or overlap with criminal systems, and similarly, how they mobilize punitive and precautionary responses to pre-criminal behavior. There are tons of examples of this in Canadian law, such as security certificates, extradition, non-conviction reports, civil forfeiture, and peace bonds. And the book provides a rationale for these processes, but there's also a fairly extensive analysis of provincial forfeiture legislation, as well as the use of peace bonds within a Canadian context. And this is the bulk of what I'm going to be talking about today. So these discussions are relatively contained within Chapter 4 of the book, which is titled Administering Criminal Law, Preventing Crime and Punishing the Pre-Criminal. The chapter posits that by prioritizing security, crime prevention, and precautionary approaches to governance, we've been able to justify or ignore quasi-criminal sanctions that are developed outside of criminal law. So here we have behavior that fundamentally seems to fit within a criminal legal process that's being addressed through other administrative forms of control. Now, why is this such a big deal? Well, we have non-criminal court systems, which are now seeing a growth of powers, and the ability to govern morality in the same way that criminal courts have been doing historically. We have the ability to impose punitive measures and sanctions without affording individuals the procedural protections that are guaranteed in a criminal legal process. And by responding to behavior through peace bonds or forfeiture, the state has the same capacity to restrict and limit behavior after the fact, or to punish frequent violations of social norms, and only needs to justify this process through suspicion of criminal behavior. So for anyone who's unfamiliar, civil forfeiture legislation allows for the seizure of property believed to be acquired from the results of unlawful activity, or any property that is believed likely to be used to engage in unlawful activity. Now, seizing property that's believed to be used in unlawful activity necessitates guessing at future likelihood of offending, but this section suggests that pre-criminal logics also enter into forfeiture of property that was believed to be acquired from prior unlawful activity. And this really relies on how forfeiture legislation establishes an ability to know past crimes. So there are several cases in this section that demonstrate the confidence that directors of forfeiture have when they seek asset seizure, as well as the scope of what they can predict or claim to know about property in order to deem it a proceed of unlawful activity. So in one example from Alberta, Mr. Cardinal was subject to forfeiting a little over $1,600, as well as his personal vehicle, after being acquitted in a criminal trial. The vehicle was seized in an attempt to govern future behavior and limit any potential reoffending, which is interesting because it wasn't a direct proceed of crime and was arguably just a means for him to offend. And in Ontario, an interim preservation order was awarded for $205,100, and the only evidence that was brought forward suggesting criminality was that the money was bundled with elastics and wasn't held in a financial institution. So this necessarily brings to light many due process concerns. Perhaps most obvious here is the risk of double jeopardy, which was seen in Mr. Cardinal's case, who was acquitted and then brought back to court. In this context, his acquittal is also undermined because forfeiture action that was brought against him was ultimately really successful. And because asset forfeiture takes place within a civil process, the state is able to circumvent substantive rights and procedural protections which are inherent within criminal proceedings. Using the civil process also allows for a reduced standard of proof. So in these cases, a balance of probabilities, rather than beyond a reasonable doubt, has the potential to infringe upon the presumption of innocence. The chapter then moves to discuss peace bonds within a critical legal lens, and this builds upon Mark Dirkson's work on specialized and traditional peace bonds. So with respect to critical legal scholarship, we can see peace bond use as inherently tied to the operation of law over time. In a neoliberal climate, peace bond use arises out of risk aversion strategies. The state here intervenes to restrict the behavior of individuals or parties that they believe may pose a risk, and here they preempt the criminal process. So the civil standard for modern peace bonds has moved beyond a risk of personal injury to considerations of both reasonably subjective and objective fears of physical and psychological harms. This process, where fear is considered only when it is objective and subjective, effectually externalizes the fear that was previously concerned with the applicant to society as a whole. And this is discussed in much more depth, but Ultimately, it's really reminiscent of other areas of law where harm moves from the individual to a community standard or to harm to public morals. And peace bonds here were traditionally applied through informal hearings dealing with private disputes, but Dirksen notes that in the mid-1990s, Section 810 of the Criminal Code was extended and began to permit alternative rationales for issuing a peace bond, and that's the specialized peace bonds that we're referring to. So these are concerns that are said to be held by the general public and not an individual party. Things like sexual offenses, dangerous offenses, and organized crime, which are sections 810.1, 810.2, and 810.01 respectively. So judges here were also provided with a wide range of conditions to impose upon bonded parties, many of which are similar to probation or judicial interim release. And if peace bond conditions are breached, or if an individual refuses to enter into a recognizance order, a period of imprisonment can be imposed. So to Dirksen's list, our work adds and includes section 810.011, which was amended in 2015 to address a growing social fear of terrorism. The work discusses the justification for these 4 specialized peace bonds in much further detail, and it also draws connection to other chapters by noting the growth in investigative powers to law enforcement through these specialized peace bonds. So, this chapter is concerned ultimately with how legislation justifies its own ability to presume offending and presume criminality outside of criminal law. By directing precautionary efforts towards property or towards a societal so-called reasonable fear that is directed at individuals, the state is expanding its capacity for governance, and it begins to police social insecurity without affording protections that are guaranteed under criminal law. Despite a different legal setting, the legislative foci are actually quite similar, and much of the language found in these cases invokes criminal law's aims to deter and punish. So I'd like to take a moment now to thank you for your interest in this project, and thank you for listening to a brief coverage of Chapter 4. And more generally, thank you for attending the launch at Robson Hall. I'm sorry I couldn't make it out, but I really appreciate the opportunity to tell you about my work. Thank you.